Good morning, Council.
Good morning, my lord.
Good morning.
Good morning, my
Good morning, my lord.
Good morning. Sorry, I'm sorry for starting late. The court sitting will start now. Registrar, call case number 1.
Yes, my lord. Resume virtually today, Wednesday, the 29th day of September 2021, before His Lordship, Honorable Justice Sanusi Kado, presiding. Suit number NICN ABJ 329, 2017, between Idigbe Emmanuel Okechukwu and 29 others, and 1, Asset Management Company Nigeria, Asset Management Company of Nigeria, APCON. 2, Destiny Dredge International Limited. 3, Lateef Omoyemi Agimgbe, liquidator of Destiny Dredge International Limited. 4, Stanbic IBTC Pension Management Company Limited. 5, Asset and Resources Management Company Limited. My lord, the parties are all absent, my lord.
Yes, appearance. Appearance.
May my noble lord be pleased.
Any appearance for the claimants? Yes.
May my noble lord be pleased.
Yes.
My name is Samuel Ona.
Yes.
I humbly appear for the first defendant.
Yes.
It is my lord. I am B.
Yes.
I am B. Lawal, my lord.
Yes.
I appear for the second and third defendants with HK Salami. B.
For
Lawal
the
and
second and third.
third, yes, my lord. B. Lawal and HK Salami for the second and third. We're much obliged, my lord.
Yes. Any other appearance?
Oh, my lord.
Yes.
My lord, the matter is slated for judgment.
Yes, I'm asking of the appearance for the claimants, appearance for the fourth defendant.
My lord, going by the screen, they are not online, my lord.
Okay. Is the judgment of the court.
As copies.
The claimants in this suit were employees of the second defendant before their employment was by letter dated 2nd day of March 2017, purportedly terminated by the third defendant, who was appointed as liquidator of the second defendant. The claimant stated that the termination of their employment was backdated to 20th day of November 26, 2016, the date the third defendant was appointed as liquidator of the second defendant. The termination of employment of the claimant was not due to their fault, but occasioned by voluntary winding up of the second defendant. The letter of termination unilaterally downgraded the first claimant from the position of technical manager to personnel assistant to head of operation. The claimants were also notified their arrears of salaries and emolument owed to them by the second defendant They were also not paid 1 month salary in lieu of notice before issuance of termination letter. The first to 27th claimants stated that as at the time of termination on the 2nd day of March 2017, they were still working as staff of the second defendant. Based on the above, the claimants instituted this action against the defendant, seeking for the relief stated hereunder. The claimants, by an amended complaint and further amended statement of material facts, all dated and filed on 21st day of February 2020, sought the following reliefs jointly and separately against the defendant as follows. A, I think the the reliefs are very lengthy, so they have been captured in the body of the judgment. I will skip reading them. Upon being served with the originating court process commencing this suit, the defendant filed their various statement of defense, while the claimant did not file reply to any of the statement filed by the respective defendant. The first defendant filed a further amended statement of defense dated 3rd day of March 2020 and filed on the 5th day of March 2020. The second and third defendant filed their joint statement of defense on the 29th day of March 2018. The fourth defendant filed his statement of defense on the 8th of May 2018. The claimants opened their case on the 5th of March 2020 and closed on the same day with the first defendant, Idigbe Emmanuel Okechukwu, testifying as CW1. He tendered several documents, about 70 documents, which were admitted in evidence and marked as Exhibit C1A to C1I, and also Exhibit 1 to 61. The first defendant also, on the 15th day of July 2020, opened and closed its case and tendered one Chukwuemeka Umonakwe, who testified as DW1. The case of the first defendant, as can be seen from its pleading, is that the second defendant was a customer of Oceanic International Bank PLC during the pendency of the banker-customer relationship between the second defendant and the Oceanic Bank International PLC. The second defendant applied for and was granted several credit facilities by the bank. When the said facilities fell due, the second defendant failed to repay same. The second defendant's indebtedness arising from the aforesaid facilities was classified as non-performing. The first defendant further stated that pursuant to the relevant provisions of the Asset Management Corporation of Nigeria Act 2010 as amended, it acquired the non-performing loan of the second defendant and became legally entitled to all the securities pledges in respect of the loan, especially the deed of all assets. The first defendant stated that it exercised its statutory and contractual rights arising from AMCON Act 2010 as amended, and the deed of all assets debenture. It took over the asset of the second defendant. The first defendant stated that it was not involved in the dispute between the claimants and second and third defendant. The first defendant also stated that it did not employ or terminate the employment of the claimants in this suit, who were employees of the second defendant. Finally, the first defendant stated that this suit does not disclose any cause of action against it and therefore ought to be dismissed accordingly. The second and third defendant did not call any witness. However, they relied on Order 40 Rule 2, Sub-Rule 2B of the rules of this court and tendered 5 documents in evidence. The documents were tendered from the bar and they were admitted in evidence and marked as Exhibit DW2A to DW2E respectively. The case of the second and third defendant, as can be gathered from their joint statement of defense, is that the second defendant does not owe any salary arrears to the claimant, The second and third defendants also stated that by a resolution made in a meeting between the board of directors, shareholders, and the creditors of the second defendant, it was resolved that the second defendant should go on voluntary winding up. By virtue of the aforesaid winding up, the employment of the claimants were frustrated. They contended that the winding up frustrated the employment of the claimant by making it impossible for the second defendant to have the legal capacity to employ, and same was confirmed by the letter of termination subsequently issued to the claimants on 2nd day of March 2017. The second and third defendant stated that there is no tussle between it and the first and third defendant for the management of the second defendant. However, the suit pending at Federal High Court in Lagos revolves on the issue of control of all assets of the second defendant secured by the deed of debenture executed in favor of the first defendant. The fourth defendant opened its case on 2nd December and closed on the same day. It tendered one Eitayo A. Ayodele, who testified as DW2. He tendered documents which were admitted in evidence and marked as exhibit DW4A to DW4B, respectively. The summary of the case of the fourth defendant is that it is a pension administrator, and out of the 30 claimants in this matter, 16 of them have retirement savings account with the fourth defendant. However, 12 of them have their account funded, while 4 do not have any fund, or their account was not funded. It also stated that it is only upon retirement or attainment of age of 50 years, or where the holder is disengaged and unable to secure another employment after a period of 4 months, that such account holder can access the fund in the account. If the holder of the account is engaged, he can only access an amount representing 25% of the credit balance in the account, while the remaining balance can only accrue to him upon attainment of the age of 50 years if he remains unemployed. They further contended that there are also other conditions precedent to the accessing the entitlement by a holder of such an account. That is to say, the access to the account have to be based on the conditions as contained in the PENCOM Act and also the regulation made thereunder. The first defendant stated that none of the claimants made any application to withdraw any portion of the benefit in accordance with the law, that the claimants are not entitled to relief sought against them for non-disclosure of course of action. At the close of evidence in chief and cross-examination of the witnesses that testified before the court, parties were ordered by the court to file their final written addresses. In compliance with the order of the court for filing of final written addresses, the first defendant filed its final written address on the 21st day of December 2020. On the 4th day of January 2020, the claimants filed claimant's final written address and reply to first defendant final written address. The first defendant on the 25th day of January 2021 filed reply on point of law to the claimant's final written address, while the second and third defendant filed their joint final written addresses on the 17th day of December 2020. However, the counsel for the second and third defendant was ordered by the court to reduce the pages of the address pursuant to Order 45 of the rules of this court. Consequently, on 12th day of January 2021, the second and third defendant, in compliance with the rules order of the court, refiled their joint statement of their joint final written address on the 12th day of January 2021. The claimants, in turn, on 4th day of January 2021, filed claimants' final written address and apply address to second and third defendant final written address. On the 23rd of December 2020, the first defendant filed its final written address. On the 1st of February 2021, the claimants filed their final written address and replied to the address of this fourth defendant final written address. In its final written address, the first defendant formulated twin issues for resolution. They are whether asset management of Nigeria, they formulated a preliminary issue and formulated two issues for resolution. One, whether the asset management company of Nigeria is a jurisdiction person that can sue and be sued. Two, whether having regard to the relief sought by the claimant in the further amended statement of material facts and the evidence adduced in this suit, the claimants have disclosed a reasonable course of action against first defendant to entitle them to relief sought against the first defendant. The second and third defendant on their part formulated also twin issues for resolution. They are whether the claimant suit as presently constituted is a misjoinder of courses of action. Two, whether the claimants are entitled to the relief sought in the further amended statement of facts dated 21st day of February 2021. The first defendant formulated a sole issue for resolution to it whether the claimant suit as presently constituted is a misjoinder of courses of action. The claimant submitted two issues for resolution. They are: one, is the claimant suit incompetent for misjoinder of parties and causes of action? Two, have the claimant pleaded sufficient facts and proved their case satisfactorily to merit the relief being sought from the court? The above issues formulated by the parties can be compressed into the following issues. One, whether the first defendant is a juristic personality that can be sued. Two, whether the claimants have disclosed reasonable course of action against the first defendant to warrant joining it as a party in this suit. Three, whether the claimant's suit is incompetent for misjoinder of parties and causes of action. Four, whether the claimants have by the evidence adduced before the court entitled or prove any of the reliefs sought before the court. I believe these four issues can settle these four issues can resolve the dispute between the parties. I shall now consider the issues one after the other. Issue one is whether the first defendant is a juristic personality that can sue and be sued. This issue was raised by the first defendant who submitted that the first defendant is not a juristic person as it was named in the suit, that the name by which the first defendant was sued is not its real names. Counsel asked the court to strike out the name of the first defendant for not being a juristic person. I have extensively captured the argument of counsel for the first defendant. On this issue, I have equally captured the argument of the counsel for the claimants regarding this issue and that of the first defendant in the body of the judgment. So I will skip the argument of counsel. When the hard copy of the judgment is made available to the counsel, they will see the argument there. I go straight to the resolution of the issue. Issue one borders on the name of the first defendant as it is stated on the processes filed in this suit. For the first defendant, the name of the first defendant as stated on the face of the originating court processes was not correctly stated. According to counsel, there is no person known to law as Asset Management Company of Nigeria that the only name legally recognized as provided under the Asset Management Act is Asset Management Corporation of Nigeria, AMCON. There is no disputing the fact that a dispute may involve legal interest of individuals, corporate bodies, ordinary statutory bodies, firms, government association, governments, association, group of persons, or other entities. As a general rule, only natural persons, i.e. human beings, and jurisdictions or artificial persons, i.e. bodies corporate, are competent to sue and be sued. See the case of Faomi versus Nigerian Bar Association number 2, reported in 1989 to Nigerian Criminal Report Part 105, page 558. Therefore, no action can be brought by or against any person other than a natural person or person unless such a person has been given by statute capacity or impliedly or by the common law legal personality under the name by which it sues or is being sued, or a right to sue or be sued by that name. This is because a lawsuit is for determination of legal rights and obligations in any given situation. Thus, only natural persons and juristic persons in whom alone such rights and obligations can be vested are capable of being parties in a lawsuit. The general rule requires both the claimants and the defendant to have legal personality. See the case of Ifeda4 versus Community Bank Limited versus Eternal Sacred Order of the Cherubian and Seraphian Saki branch, reported in 2001, 11 Nigerian Criminal Report, part 713, page 508. See also in Joku versus United Bank for Africa, for United Africa Company Foods, reported in 1999, 12 Nigerian Criminal Report, part 632, page 552. See also Gani Farmi versus MBA Sufra and Management Enterprises Limited versus Otu Sanya, reported in 1987, 1 Nigerian Criminal Report, part 55, page 179. A natural person must be in existence at the time of the suit. In the case of a juristic person, it can sue or be sued in its corporate personality. If its corporate personality subsists, see the Nigerian case of Nigerian Nurses Association and others versus Attorney General of the Federation and others, reported in 1981, 11 to 12 SC, page 1. The name of a competent party to a suit must be the real name by which it is known. In the case of a natural person, it and its corporate name, in case of a natural person, and in case of a corporate person, the corporate name, in case of non-natural legal entity. See the case of Novel versus Parochial Committee of St. John Aroloyo, Lagos. In the case at hand, the name given for the first defendant in the originating court process is Asset Management Company Nigeria Limited, as a company of Nigeria, but by the provisions of the AMCON Act 2010 as amended, the name given as the name of the first defendant is Asset Management Corporation of Nigeria. The question now to be settled is whether the name as stated on the court process for the first defendant is a name of a non-juristic person as argued by counsel for the first defendant, or is it a mere misnomer as argued by counsel for the claimants. The law is well settled. The well is well settled that a non-juristic person generally cannot sue or be sued a nominee, and an action commenced by or against such a non-juristic person is incompetent and liable to be struck out. It will seem, however, in this peculiar case, the first defendant completely misapprehended the legal principles decided in very many of the cases cited are relied upon on the subject of this suit. It is to be noted that the extant principle is not that where an entity close with legal personality that is wrongly described in a suit, such an entity automatically transforms into an entity not known to law. The test for determining whether a given name is in a suit is that of a non-juristic person or is a misnomer is that of a reasonable man. The judicial authorities on misnomer are settled that a misnomer can be said to be a mistake in the name, i.e., giving incorrect name to a person in the writ of summons. It occurs when a mistake is made as to the name of a person who sued or was sued, or when an action is brought by or against the wrong name of a person. See the case of MS4J Continental Limited versus Corona S and Co. reported in 2006, 11 Nigerian Criminal Report, Part 991, page 365. See also the Registered Trustees of the Airline Operators of Nigeria versus NAMA 2014 LPLR 22372SC. The Apex Court has held that a misnomer occurs when the correct person is brought to court in a wrong name. It is not the description or designation by which a party sues or is sued in an action that determine whether that party is a juristic entity or not. It is rather a function of due registration and or recognition under the extant laws that usually tilt the scale in favor of one party or the other. For instance, it is not enough to assume without proper investigation that an entity must be a limited liability company merely because the word limited is attached to its name. It is also not enough to assume that an entity is not a limited liability company merely because of the omission of the word limited in its name. See the case of Bank of Baroda versus Eyalobani Company Limited, reported in 2002, 13 Nigerian Criminal Report, Part 785, page 351. See also the case of Revtico SA Geneva versus Africa Bank Nigeria PLC, reported in 2013 LPELR 20662SC. A misnomer, when associated with issues of juristic personality and misdescription of names of a party of parties, simply means the wrong use of a name or a mistake in naming a person, place, or things, especially in a legal instrument. Therefore, a misnomer in the context of litigation is said to occur where the entity suing or being sued exists, but a wrong name is used to describe that entity, like how it happens in this case. See the case of Max Line versus AD 211 MJSC 157 at 179. In other words, a misnomer is said to occur in a legal proceeding when the correct person comes or is being brought to court under a wrong name, but not when the wrong person sues or is sued in an action. See MS4J Continental Limited Sufra. The test which has been applied by the courts to ascertain if title of a party shown on the originating court process is a misnomer is a settled one. As I have said earlier, it is the test of a reasonable man. One factor that operates on the minds of the recipient of the originating process is whether there is or is not another entity to which the description on the writ might refer. The test is usually that of reasonable man of some kind, to which how will a reasonable person receiving the document take it? If in all circumstances of the case and looking at the document as a whole, he would say to himself, of course, it must mean me, but they have got my name wrong. Then there is a case of misnomer. If on the other hand, he would say, I cannot tell from the document whether they mean me or not, and I shall have to make inquiries. This would have gone beyond the
Which account are you using?
the arm of a
Move this
misnomer.
one.
See the cases of Davis versus LC Brothers Limited, reported in 1963 All England Roll Report. See also Melafia versus Veritas Insurance, 1986, for Nigerian Criminal Report, part 38. See also Nwabuze versus Knife Force, reported in 2006, 8 Nigerian Criminal Report, part 983, page 480 at 526 to 527. In the case at hand, can it be said that the best defendant now protesting is not a juristic person, or is it a wrong description, i.e. a misnomer? Having regard to the circumstance of this case and the state at which the issue of juristic personality was raised by the first defendant, it goes without saying, therefore, that the first defendant who did not protest the name used, and in fact filed processes using such name, cannot now be had to complain at this stage. This is because he is deemed to have waived his right and is therefore stopped from contending the contrary, as rightly submitted by learned counsel for the claimant. The wrong use of the name did not overreach or put the first defendant to any form of disdain in the absence of any earlier complaint thereof. The use of the name, in my view, is at best a misnomer, and which did not occasion any negative effect. This court, under its inherent powers, has the jurisdiction to correct such inconsequential error, which did not require any formal application to be made. A similar situation in the case of Afolabi and 2 others versus Adekule and another, reported in 1993, 8 SC 98, is in evidence, wherein the Supreme Court, in the lead judgment delivered by Anyagulu JNC, as he then was of blessed memory, approved the power of Court of Appeal to amend the Capacity Court approved of this kind of approach, so as to ensure that the duty of the court to do substantial justice is always upheld and not put into jeopardy. It is pertinent to note that this power of amendment of capacity of party was not also made clear in the cases of some Development Company of Nigeria Limited reported, and the case of Mayax Line Supra, where it was emphatically laid down that the power of the court, that is to say the High Court or Trial Court, the Court of Appeal, the Supreme Court, have the power to correct a misnomer, have an inherent power to correct a misnomer. Once a party sought for an amendment to correct the mistake, such an application will readily be allowed. See the case of Njoku versus UAC Foods, 1999, 12 Nigerian Appeal Report, part 632. See also Unwocha versus Federal University of Technology, 1996, 1 Nigerian Appeal Report, part 422, page 112. See also Ajadi versus Ajibola. See also a host of other cases cited there, wherein it was held, it is settled that where an amendment sought relates to a mere misnomer, it will be granted almost as a matter of course, found in the Maker Agu JSC. Also in Bello and Ori versus Mohammed and others, 2005, LPLR, Adeke JSC, as he then was observed, a mistake or misnomer in the name of a party will not be shaped proceeding duly initiated or properly filed. It will also be unjust to mistake emanating from the chambers of his learned counsel to the petitioner or registry or tribunal, or for a matter beyond its control. The position of the law is clear. An application to amend a mistake in the name of a party should be granted almost as a matter of course. See Commerce Association Limited versus Ali Sufra. But the applicant must provide the court with reasonable grounds of excuse for making the said mistake, and there must be no doubt as to the identity of the party in question. See in Jamanze versus Shell BP Port Harcourt, 1966, NSCC Volume 4, page 6. Finally, the court must ensure that applicant is not penalized for a mistake made by any other person or for a matter beyond his control. See Bello and others versus Mohammed. In the case at hand, the first defendant has never told the court how the wrong description of the name has substantially misled the parties and has not also shown any miscarriage of justice was thereby occasioned. See the cases of Bayo versus Injida. See also Ajadi Ajibola. See also Bajoga versus Government of the Federal Republic of Nigeria. I shall allow the amendment to the name of first defendant to be made by substitution of the corporation with company in the name of the first defendant so as to reflect the true name given to it by the statute establishing it. The issue, therefore, is resolved in favor of the claimants. I now go to issue 2. The issue 2 is whether the claimants have disclosed reasonable course of action against the first defendant who warrant joining him as a party in this suit. The first defendant in arguing this issue, the counsel for the first defendant in arguing this issue submitted that the court have in a plethora of has initiated what constitutes course of action, has stated what constitute a course of action, a reasonable course of action. Several cases were cited by counsel. I have captured the submissions of counsel for and against the issue of course of action in the main body of the judgment, so I will skip reading the submissions of counsel. I will go straight away to the resolution of the issue. I have given deep consideration to the submissions of counsel as well as the pleadings and evidence adduced before the court. What is not in dispute is the fact that the first and third defendant are engaged or entangled in a legal battle as per Exhibit DW2A, which is the originating process filed at the Federal High Court Lagos Division. It is clear from Exhibit DW2A that the dispute between the first defendant and third defendant is on the asset of the second defendant. A course of action did not aggregate factual situation. The claimant relied on to approach a court of law for ventilating his grievances. See Bello versus Attorney General of Oyo State. The apex court held that in that case, course of action is constituted by the bundle of aggregate facts, which the law will recognize as giving the plaintiff a substantive right to make the claim against the release or remedy being sought. Thus, the factual situation relied upon must constitute the essential ingredients of an enforceable right or claim. See Akilu versus Paomi, number 2. See also Savage versus Uwechia, reported in 1972 on All Nigeria Law Report Part 1, page 251, as rightly submitted by counsel for the court to determine course of action. The pleadings of the plaintiff must be considered and not the defense. However, since evidence has been given in this case, the court is entitled to look at the entire processes file and the entire evidence before it. A careful perusal of the pleadings of the claimants in this case and the evidence adduced clearly shows that the claims of the claimants borders on termination of appointment payment of salaries, arrears of salaries, emoluments, and pension and other entitlement like national housing scheme, etc. The claimants are by the third defendant issued to terminate their appointment. They are also claiming certain payments. It is interesting to note that the abatements in the statement of facts and the front-loaded documents have clearly established that the main grounds of the claimant that encouraged them to institute this action was their belief in the nullity of the letter of termination. The issuance of the letter of termination is enough to establish a course of action against the issuer and donate legal right to the claimant to approach this court for redress or alleged wrongdoing. However, the question now to be settled is, can the first defendant be said to be proper party before this court in view of the fact that the letter of termination, which forms the basis of approach to this court to seek redress, was also issued by the first defendant? The claimants did not assert that they were employed by the first defendant. And also from the submission of counsel for the claimants in the final written addresses before the court, it appears the claimants have abandoned the claim for terminate have abandoned the issue of letter of termination issued by the third defendant, because they have agreed that their termination is now with effect from 20th day of November 2016, when the third defendant was appointed liquidator of the second defendant. It is to be noted that in employment litigation, the person making claim must be able to prove to the satisfaction of the court that there was, in fact, an employment relationship between him and the defendant being sued to make claims for salaries, allowance, and pension. It appears to me that the claimants have joined the first defendant in this suit based on Exhibit DW2A, the suit pending at Federal High Court, where the first defendant is seeking to continue to have control, is seeking to continue to be in control of assets of the second defendant, which the third defendant, as appointed liquidator, is also asserting right of control. Apart from the reliefs being sought jointly, there is no specific abatement in the pleading that clearly states how the first defendant become liable to the claimants. The mere fact that the first defendant has admitted being established and vested with power of purchasing non-performing debts of companies is not enough to make him liable to the claimants, as there was no abatement that the non-performing debts which the first defendant had purchased included the unpaid salaries, allowances, and entitlement of the claimants, more particularly when there is no evidence that the third defendant has been appointed as liquidator. When there is evidence that the third defendant has been appointed a liquidator of the second defendant. Since there is no real controversy pleaded between the claimants and the first defendant, the case of the claimants against the first defendant has become academic and hypothetical. The courts have been enjoined not to engage in academic exercise. Courts are meant to deal with live issues. For court to exercise jurisdiction on a matter, there must be real controversy calling for resolution. In the absence of any real controversy, the the court cannot embark on an exercise of rendering advisory opinion. There must be actual controversy. It is therefore my view that this suit against the first defendant is, as it is now constituted, is an academic, hypothetical, and moot issue, which does not deserve any attention or pronouncement. See the case of Bona versus President, Federal Republic of Nigeria, reported in 1997, 5 Nigerian Report, Part 504, page 281. See also Federation versus ANPP, 1995, 5 NWR 504, 281. See also Atake versus Pejuka. See also Tamiola versus Sobeo and Martin Geodata Limited, and host of other cases cited therein. It is glaring from the pleadings and the evidence on the record that the case at hand can be effectually and completely determined without the presence of the first defendant. This is because there is no evidence that first defendant employed the claimants. There is also no evidence that the first defendant terminated appointment of the claimant. The only connection of the first defendant may have in the alleged dispute between the first and third defendant, and the true position of who to control the second defendant actors could only be ascertained at the end of the suit at the file at the Federal High Court, as shown in Exhibit DW2A. From the complaint of the claimants, the first defendant is not a necessary party to the suit. By decided authority, a necessary party is one whose presence is very necessary to enable the claims or the central issues or issues in controversy in the suit to be completely and effectually determined. In other words, the presence of such a party is mandatory. Without such a party, the claim or the central question in issue cannot be fully and finally settled. See Green and Green, reported in 1987, Nigerian Criminal Report, Part 61, page 481. This clearly shows that the first defendant in this suit is not a necessary party and shouldn't have been joined as a party in the first instance. In the circumstances, I struck out the name of first defendant for being not a proper party before this court. Issue 2 resolved in favor of first defendant.
Let's copy.
I shall now go to issue number 3. That is whether the claimant suit is incompetent for misjoinder of party and causes of action. The second and third and fourth defendant all argued, while relying on several cases, that the concept of misjoinder of parties and cause of action in contract is same as in tort. That is to say, several claimants are not allowed to join in one suit or in one action because they have separate and distinct cause of action. For claimants to join in one action, they must have common interest. I have captured the argument of counsel for and against the issue of misjoinder. So I will keep reading the argument of counsel. I will go straight to the resolution of the issue. This issue borders on the name of the first defendant as it is. Sorry. I will go to the resolution of issue 3. A single cause of action is by itself a subject of a suit. So where a party has a single cause of action, he can approach the court. However, it does not follow that for every cause of action a person has a separate and distinct suit must file a separate and distinct suit. This is because the rules in many cases allows a claimant to sue for different causes of action in a suit. By means of this device, multiplicity of actions is avoided, thereby reducing cost and duration of trial. This is done by bringing various causes of action in one action, defendants. As in this case, a defendant need not to sue irrespective of all causes of action, but only in some, or only need not to be sued irrespective of all causes of action, but only in some or only one of them. It is not only different and distinct causes of action that may, in certain cases, be included and tried in one suit, but also sometimes two or more persons may be joined in one action as plaintiffs or as defendants to prosecute their common or personal claims, or to defend jointly or individually the claims against them. See the case of Ayankoya versus Olukoya, reported in 1996, 2 SCNJ 292 at 305. See also Ade Diran versus International Transport Limited, reported in 1991, 9 Nigerian report, page 155. It is to be noted that once there is rules for it, a joinder is invariably allowed as of right. No leave of court is required. However, in the interest of convenience of trial, the court may order separate trials where necessary. It must be remembered that parties can only be properly joined to the extent permitted by the rules. The National Industrial Court of Nigeria Civil Procedure Rules 2017 have comprehensively make provisions on joinder of parties and causes of action. The applicable provisions to this action is Order 13, Rule 1 of the rules of this court, which provide, I quote, all persons may be joined in one action as claimants in whom any right to relief is alleged to exist, whether jointly or separately, and judgment may be given for such claimants as may be found to be entitled to relief, and for such reliefs as the claimants may be entitled to without amendment. The substance of the above quoted provisions of the rules of this court is that all persons may be joined in one action as claimants in whom any right to relief is irrespective of all arising out of the same transaction or series of transactions is alleged to exist, whether jointly, separately, or in the alternative, where if such persons brought separate action, any common question of law or fact would arise and judgment may be given for such one or more of the plaintiffs as may be found to be entitled to the reliefs, for such reliefs as he or they may be entitled to without amendment. It appears from the provisions of Order 13, Rule 1, Supra, that the requirements for joinder of claimants under the rules of this court are that: one, the right to relief claimed in the suit must be vested in the claimants, whether jointly, separately, or in the alternatives. Two, the right to relief must be irrespective of or arise out of same transaction or series of transactions. And three, if all the plaintiffs had brought separate action, a common question of law or fact would arise in all such action. See the case of Newspaper Corporation versus Oni, reported in 1995, 1 SCNJ, page 218 at page 232. It is clear without any equivocation that the joinder of persons or parties is in one action as claimant, as well as joinder of causes of action are permissible under the rules of this court. as provided in provided the foregoing conditions enumerated are met or established by the claimant. The questions that need answer is, have the claimant in this suit fulfill or satisfy the conditions for invoking the provisions of Order 13 Rule 1 for them to join in one action to seek redress in a court as they did in this case? The answer to the further can be found in the statement of material facts, further amended statement of material facts and the evidence before the court. In the pleadings of the claimants have stated that they were employees of the second defendant, but on the second day of March 2016 or 2017, the third defendant, as liquidator of the second defendant, issued a letter terminating their appointment. The claimants instituted this action to claim their unpaid salaries and allowances and pension, and to also contest the validity of the letter of termination. The second and third defendants on their part have admitted that the claimants were employees of the second defendant, but they have their employment terminated. It was also argued that the termination of the claimant's employment took effect from 20th November 2016, the date of appointment of the third defendant as liquidator of the second defendant. It is clear to me that the claimant's complaint before the court arose out of the same transaction or series of transactions which was termination. Which was termination of their appointment due to liquidation of the second defendant. It is also without any doubt that if the claimant have separately brought their action before this court, there will be a common question of law or fact that would arise in the circumstances. I am convinced that the claimants have fully satisfied and fulfilled conditions for bringing a single action to ventilate their grievances with the defendants in this suit, except the 28th, 29th, and 30th claimants who their own termination of appointment was not due to liquidation of the second defendant. Their own termination could not be said to be in the same transaction or series of transactions as it relates to the liquidation of the second defendant. In this wise, the claimants were on right footing in commencing an action in the way they did. However, having found that the 28th, 29th, and 30th claimants ought not to have been joined in this case, I hereby struck out the name from this suit and non-suit them for not being properly before the court. It is to be noted that the Supreme Court was faced with a similar problem in the case of Ayam Koya versus Olu Koya, reported in 1996 for Nigerian Criminal Report, page 440, where a similar situation was brought before a similar issue was argued before the High Court of Oyo State. After the ruling, it went to the Court of Appeal, and from the Court of Appeal to Supreme Court. And the Supreme Court in that case affirmed that several claimants can be joined in one action to pursue their different courses of action. It is to be noted that even where there is genuine case of misjoinder, that alone cannot initiate proceeding, since by the rules of court, no course of action in a matter can be defeated by reason of misjoinder or non-joinder of parties, and the court is empowered in every cause or matter to deal with this matter in controversy so far as regards the rights and interest of parties actually before it. Therefore, where there is an established case of misjoinder or non-joinder of parties, such misjoinder or non-joinder shall not defeat the cause of action. Non-joinder or misjoinder will not be fatal to the proceedings. The court may, however, order a retrial in appropriate cases. That is when there is an appeal, when the issue was decided in an appeal. In other words, misjoinder is a procedural irregularity which does not affect the competence or jurisdiction of the court, but where the irregularity leads to injustice or to unfairness to the opponent party, it may lead to setting aside of the judgment on appeal. See the case of Cross River State Newspaper Corporation versus Oni Sufra. See also Babayeji versus Ashamu, reported in 1998-9 Nigerian Law Report, part 567, page 546. See also Ayolinde versus Oni, reported in 2003 Nigerian Law Report, part 649, page 348. See also FGP Limited versus Duru, 2017, 14 Nigerian Law Report, part 1586, page 483. I am in support of counsel for the claimant in the submission to the effect that the case relied on by the defendants in raising issue of misjoinder are inapplicable to the case at hand. The reason being that it is the rules of court that determine whether joinder of parties and causes of action are allowed. The rules of courts in the cases relied by the defendants by counsel for the defendants are not on all fours with the rules of this court. Each court must be governed by its rules. This court has its own rules, and the rules permit joinder in the way claimants have done in this case. The position of the law is well settled that no cause or matter shall be defeated by reason of misjoinder or non-joinder of parties, and the court may in every cause or matter deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. See PNOC Investment Limited versus Hotel Presidential, reported in 1982, 12 SC page 1. This issue is resolved in favor of the claimant that the case, it is only in respect of 28th, 29th, and 30th defendants that there is misjoinder. For the first to 27th claimants, there is no misjoinder and the case is properly before the court. I so find and hold. I now go to issue number 4, which is the final issue in this suit to determine this suit, whether the claimants have via the evidence adduced before the court proved entitlement to any of the reliefs. In arguing this issue, counsel for the second, third defendant submitted that the claimants are not entitled to any of the reliefs being sought in this suit. It is submitted by counsel for the second and third defendant that in order to actively demonstrate the claimant's lack of entitlement to any of the relief sought therein, it will be proper to consider the reliefs contained in the further amended statement of facts based on 4 sub-issues. The sub-issues are: 1, the third defendant lacked legal capacity to terminate the claimant's employment. B, the termination of claimant's employment is illegal since they neither flouted any rules nor committed any wrong act. 3, the claimants should be declared redundant, further alternative, and the relief B. 4, the claimant's entitlement to the sum of 200,667,843 naira 3 kobo only as claim for arrears of salaries, emolument, and pension. I have in the body of the judgment capture argument of counsel for and against issue number 4. I shall therefore skip reading the argument. Counsel will have the benefit of reading the argument when they get the hard copy of the judgment. I now go straight to the resolution of issue 4. This issue is one that will determine the substantive suit or claims of the claimants, in that it encapsulates all the reliefs being sought by the claimant from the court. However, before proceeding with the resolution of the issue, it will be necessary to deal with some issues raised by addresses of counsel. The first is the claimant has copiously made reference to unreported ruling of the Federal High Court Lagos Division in suit number FHC/L/CS/217/2017, delivered on the 12th day of October 2017, to impeach the unreliability of the evidence given by DW1 in respect of the dredgers, as according to counsel, it was contradictory, and a witness who contradicted himself on materials point in dispute, his entire evidence is unreliable and ought to be rejected. Counsel, because the court cannot pick and choose which version of the evidence it will rely on. Let me say that the law is well settled beyond reproach that counsel relying on unreported cases have a bounden duty to supply to the court certified true copies of the decision they want the court to make use of. See the case of Oni versus Governor of Ekiti State, reported in 2011, Nigerian Report for 1664 Augi JSC. By not supplying the court with the unreported rulings of the Federal High Court, the counsel has failed in his duty. In the circumstances, all submissions made in respect of the unreported ruling of MB Idris J, as he then was now JCA, of the Federal High Court, are hereby discountenanced, and there is nothing to prove the shaking of credibility of DW1. In fact, the entire argument of counsel has now become redundant. Due to the striking out of the name of the first defendant from this suit, due to non-disclosure of course of action. The next pertinent issues to be resolved here is the issue of the redundancy. The counsel for the claimants has, in his claimant's final address, conceded that the relief for redundancy cannot on the state of the law be granted. But since the monetary claims made by the claimants against the defendant are over 99% based on arrears of salaries and other emolument calculated over a certain period before the said defendant was appointed as liquidator, the claimant are entitled to pursue their entitlement, and such entitlement or right having been categorized as debt, they can recover such a debt. What the submission of counsel for the claimant shows is that the claimants have abandoned their reliefs in some of their reliefs in paragraph 33 of the further amended materials part. In the circumstances, the two all the reliefs that relates to redundancy and all the submissions and evidence in this suit regarding redundancies are hereby discountenanced, since the counsels the counsel for the claimants in the final written address has considered that the redundancy claim cannot be made out or cannot be granted as per the state of the law. In the circumstances, all the issues, evidences, and argument canvassed for redundancy are hereby discountenanced insofar as this judgment is concerned. Another issue worthy of consideration is the claimant's claim for contributory pension owed due to the claimants, owed or due to the claimants. The post-defendant has stated that out of the 30 claimants, 16 maintain retirement savings account with the first defendant. However, only 12 of them have their retirement savings account funded with various amounts standing to the credits in the balance, to the credit in the accounts, while 4 out of the 16 holders have zero balances as their retirement savings account was not funded. It was stated access to the fund is in the retirement savings account is subject to qualifying terms and conditions stipulated by the Pension Reform Act and the regulation for the administration of the retirement and termination benefit. A retirement savings account holder can only have access to the fund upon retirement or when he attains the age of 50 years, whichever is latter. It was stated none of the 12 claimants having saving account with the first defendant have approached or filed an application to the first defendant to withdraw any portion of their retirement savings in their account in line with the extent law and rules and regulations. The statement of accounts and the retirement savings account from the 16 claimants having account with the first defendant were tendered and admitted in evidence as Exhibit DW4A and DW4B. The counsel for the claimants has argued that the plea of the fourth defendant that the condition precedent to accessing of the fund in the retirement saving account have not been fulfilled before this suit was filed will merely rob this court of jurisdiction and not entitle the suit to be dismissed. Rather, the natural consequence for want of jurisdiction is striking out order. A combined reading, after careful examination of the submissions of counsel and the evidence before the court, I have cause to examine the provisions of the Pensions Reforms Act 2014, a combined reading of Section 7, 11, and 16 of the Pension Reform Act 2014 will reveal that for a contributor or holder of retirement pension account to be able to access the funds in his account, in his retirement saving account, he must fulfill certain conditions as to his age at which he left service and the percentage which the law allows him to withdraw from the funds. He is not allowed to withdraw the entire amount. These conditions pointed out by the first defendant have not been fulfilled. These conditions contained in these sections of the law and as pointed out by the first defendant have not been fulfilled or met by the 12 claimants that have funds in their retirement savings account with the post defendant. In the circumstances, I am of the view that the claim for pension as it is premature for non-fulfillment of conditions based on which a holder of the account can benefit from the savings from the retirement savings account. In the circumstances, the claim for pension is not properly before the court and it is hereby struck out. One other very important issue that need to be resolved here is the contention of the defendants that the evidence of CW1 insofar as it relates to the remaining claimants in this suit, i.e. second to 30th claim defendants, is hearsay. The counsel for the claim to the second to 30th claimants, not defendant, is hearsay. The counsel for the claimants vehemently objected to the positions of the defendants on the evidence of CW1 being a hearsay in respect of the claimants' counsel. For the counsel for the claimants heavily relied on the ruling of this court delivered on the 3rd of May 2020 regarding the objection to the admissibility of letters of appointment of the claimants when they were sought to be tendered in evidence. This court, after listening to the submissions of counsel, overruled the objection and admitted the document into evidence. The counsel for the and submitted that the ruling of 3rd day of May 2020 by this court will operate to stop the defendant from contending that the evidence of CW1 is hearsay. There is no doubt that the law is solid, like the Rock of Gibraltar, when it comes to the issue of estoppel, that any issue the court has considered and rendered a decision on it cannot be reopened by the court or by a court of coordinate jurisdiction. That decision can only be overturned. That decision can only be overturned or reversed on appeal. Issue estoppel, which occurs when an issue had earlier been adjudicated upon by a court of competent jurisdiction, and same issue comes incidentally in question in any subsequent proceeding before the court, will not be allowed. The rule that once one or more issues have been raised in a course of action and distinctly determined or resolved between the same parties in court of competent jurisdiction, then as a general rule, neither party is allowed to relitigate that or those decided issues all over again in another action between the same parties. As doing that will offend the rules against reopening a case by the same court or tribunals that have decided on it. See the case of Skyblind Nigeria Limited versus Unwafe, reported in 2029 Nigerian Nuclear Report, part 1730, page 541. The defendants have argued that the evidence of this claimant, who testified for himself and on behalf of the second to third claimants who have separate and distinct course of action, is at best hearsay for the claimant. The ruling of the 5th day of March 2020, where this court overrules the objection to document tendered by CW1, the issue cannot be often resurrected as it has already been buried, is dead and already been buried. It is to be noted that from the ruling of this court, the objection that was taken, which the court handed down a bench ruling, was issue of admissibility of letters of employment, compensation package, and the review of salary, and not the evidence of CW1. The objection to the admissibility of documents sought to be tendered in evidence was overruled and the documents were admitted in evidence as Exhibit 1 to 61. It was also ordered that the admission of the document will be subject to appropriate evidential value to be apportioned to them at the trial when the court is writing its judgment. It is to be noted that there is a world of difference between admissibility or admitting document in evidence and evidential value of the said document. This distinction is very vital in order not to lose sight of the essence of tendering evidence before the court. In the ruling of 5th day of March 2020, the issue dealt with is that of admissibility of document and not evidence of CW1. I shall now consider the reliefs being sought by the claimants and see whether they have proved entitlement to any of the reliefs contained in the further amended statement of materials fact filed in February 2021. The details of reliefs being sought are contained in paragraphs 33 of the further amended statement of facts, while the summary of the claims is as contained in paragraph 34 of the further amended statement of material fact. The claims or reliefs being sought were also stated in paragraph 36 and 37 of the witness statement on oath of 21st day of February 2021, deposed to by the first claimant who testify as CW1. However, I wish to point out here that claims reliefs as stated in paragraph 34 of the further amended statement of facts do not tally or correspond with the claims reliefs as stated in paragraph 37 of the witness statement on oath, which was evidence the first claimant as CW1 adopted as his evidence in proof of the case of the claimant on the 5th day of March 2020. In the course of giving evidence in chief, I shall reproduce the said paragraphs for ease of reference. Paragraph 34 of the further amended statement of material fact read as follows. The claimant total claims against the defendant jointly and severally or severally therefore are as follows. A, as against first and third defendants, the total sum is 181,156,552 naira 25 kobo, being salaries and emoluments owed the claimant. B, as against first and second and third defendants, the total sum of 500 million general damages for material, psychological, and physical stress arising from long months of owed salaries and emolument. C, as against fourth and fifth defendants, the total sum of 19,511,321 naira 5 kobo, being 2.5% of the contributory pension owed due to the claimants as amply pleaded above. Paragraph 37 of the witness statement on oath read as follows. Our claims against the first, second, and third defendant jointly and or separately therefore are as follows. A, as against first and second and third defendant, the total sum of 143,275,279 naira 69 kobo, being salaries, emolument owed the claimant. B, as against first, second, and third defendant, the total sum of 500 million general damages. C, as against fourth and fifth defendant, a total sum of 18,943,715 naira 6 kobo, being 2.5% of contributory pension owed or due to claimant as amply pleaded above. The counsel for the claimants has maintained that the claimants have proved their case and at least they are entitled to judgment in respect of claim for salaries and emolument against the first, second, and third defendant, subject only to reduction in their claims before arrears of salaries and emolument as contained in their reliefs claims in the further and better statement of material fact. The claimants took this position because they have considered that the termination of appointment took effect from 20th day of November 2016, when the third defendant was appointed as liquidator of the second defendant, and not as at the date of the letter of termination. The position taken by the claimants in their final written address clearly goes to show that they have abandoned their abatement to the effect that termination of their employment was illegal, null and void, because it was done retrospectively and by the third defendant, whom according to them does not have power to do so. Indeed, their twist regarding their claim shows that they have abandoned their claim regarding invalidity of termination of their employment. Their main claim, the claims seeking for payment of invalidity of termination of their employment. Their claim for reliefs seeking for payment of salaries and emolument leaving only the claims for reliefs for payment of salaries and emolument. The claimants have insisted that they have, by the evidence of CW1 and documentary evidence tendered before the court, established or made a prima facie case to which the burden of proof has shifted to the first, second, and third defendant. It is submitted that the second and third defendants, by refusing to field a witness to testify in proof of their defense as pleaded, have abandoned their pleadings. Which denied the relief claims on salary, which denied the claims on salaries and emolument, and there is nothing which the court can put on scale of justice apart from the evidence of the claimants. Let me reiterate that the law is that pleadings cannot constitute evidence, as abatement in pleadings on which no evidence is adduced are deemed to have been abandoned. For mere abatement in pleadings without proof do not constitute proof of such facts unless such facts are admitted. See the case of Ifeto versus SPDC 2006 LPL RSC. See also however, as can be seen from relief 36 3A, the relief is for salaries and emolument, which is a claim for special damages, which by the case of NNPC versus Clipo Nigeria Limited 2011, and the case of 7F Company PLC versus Augustus, must be specifically pleaded and strictly proved. And by the case of Gabriel Atibi Cable Metal, where the Supreme Court held that a claim is circumscribed by relief's claim, the duty of plaintiffs, therefore, is to plead only such facts and materials as necessary to sustain reliefs and adduce evidence to prove same. The defendant respondent, the claimant, the respondents, the defendants have also insisted that the claims of the claimant is for special damages, which should be specifically pleaded and particularized. Counsel insisted that the claimants have not produced any evidence to prove their claim. In answer, the claimants argued that the defendants have abandoned most of their pleadings, which means issues have not been joined on the issue of non-payment of salaries. The claimants also maintain that the evidence of CW1 and the documentary evidence tendered in the course of the proceedings have proved entitlement of the claimant to the reliefs being sought on the salary and emolument. The defendant on their part have also argued that the evidence of the claimant's witness in so far as it relates to second to 30th claimant is hearsay. They also argued that the claimants dumped exhibits before the court without evidence. The claimants are seeking for payment of arrears of salaries and emolument, as well as a refund of National Housing Fund, National Housing Scheme contribution. In a claim of this nature being claimed for special damages, the claimant must prove two things: entitlement to the sum and how they came by the contents of the claim. In labor relations, the burden is on the claimant who claims monetary sums to prove not only entitlement to the sum, but how she came by the quantum of such claim. And proof of entitlement is obtained by reference to an instrument or document that grants it. See Mr. Mohammed Dungus and others versus ENL Consortium Limited, reported in 2015, 60 NLLR, part 208, page 39. Note the oral testimony of claimants except if corroborated by some other credible evidence. See also the case of Stephen Ayogu and 16 others versus Mobile Producing Unlimited and another unreported suit number NICN/LA/38/2010, the judgment of which was delivered on 27th October 2017. In fact, Mr. Joseph Akinola, the case of Joseph Akinola and others versus Lafarge Cement Wafco, Nigeria PLC 2015 LPLR, specifically cautioned against reliance on oral evidence as proof of such. The claimant presented Exhibit CW1A to CW1I and Exhibit 1 to 61 as proof of both their entitlement and how they came by the quantum of their claim. Apart from Exhibit CW1, CWB, CW1CH, and CW1I, all other exhibits tendered by the claimant emanated from second and third defendant. There is no evidence before me to establish that exhibits that were issued by the second and third defendant are not genuine or they are forged. For exhibit from the claimant's solicitors, they cannot serve the purpose of proof to establish any right to claim or proof of same. The evidence, they are only evidence of a demand, not entitlement. They are only evidence that a demand has been made for the payment of the arrears of salaries and emolument, but it was not paid. To prove claim for arrears of salaries, the court must be told in the pleading what the claimant's salary is, upon which he lays his claim. The claimants have maintained that they have specially pleaded, particularized, and proved their claim for salaries and emolument. I shall at this point refer to paragraph 18 of the further amended statement of material fact, where the second to 27th claimant stated that they were paid salaries and emolument up till September 2015. Therefore, there was no payment in October 2016, when the second defendant paid their September salaries and emolument. According to second to 27th claimants, apart from September salary and emolument that were paid on 17th day of October 2017, they have not been paid since October 2015, till the time of filing this suit. The first claimant was paid up till December, as at period other claimants were paid. The claimants in paragraphs 23 of the further amended statement of facts stated that 2.5% was deducted from their salary for National Housing Scheme. Likewise, 10% deduction made for tax but was not remitted. They also stated they are entitled to outstanding daily allowances paid junior staff ranging from 1,500 to 3,000 naira. As pointed out earlier, the claimants have to establish for the court to come to the to be able to come to the conclusion that yes, they are entitled to their claim. The claimant must be able to prove to the court that they were actually, the actual payment made to them was only up to September 2015, as claimed in paragraphs 18 of the statement of further amended statement of claim. The defendant have insisted no evidence established their claim, and they dumped document on court. I have given the submissions of counsel on dumping and lack of evidence consideration. I have noted that the first claimant testified for himself and on behalf of the other claimants in this suit. It is my view that the first claimant is not competent witness to testify on behalf of other claimants in this case, for the simple reason that he was not in a position to testify on a contract of service that he was not a party to, the letters of employment, compensation packages, and were issued to individual claimants. Likewise, the salaries were paid to the claimants, individual claimants, as per paragraphs 18 of the further amended statement of fact. The letter of employment compensation packages only stated the gross entitlement of the claimants and not the net entitlement, which is what is their take-home pay. The first claimant is not in a position to know that the claimants would have done better, is not in a position to know whether the claimants have actually been paid or not. The claimants will have done better by tendering pay slips or bank statement of accounts showing what they are actually entitled to as salaries, if the claimants have also called a member of staff that prepares their salary to give evidence that would have been more credible than the evidence of CW1, who is not a party to preparation of their salary, who was not party to their contract. In view of this, and in view of the cases of Nwosu versus Odiaja, 1991 Nigerian Criminal Report Part 125, and the case of FHA versus Olaimi 2017 LPLR 43376, I came to the conclusion that the evidence of first claimant as it relates to the case of other claimants have no evidential value, to establish any claim by the second to the 30th claimant or second to the 27th claimant, since the 28th, 29th, and 30th defendants have their name struck out of the suit. To make the claimant case worse, they did not particularize the claim and in the body as they were supposed to do. The Court of Appeal Calabar Division was faced with a similar situation as in the case at hand. In that case, the court refused to grant the salaries and other entitlement of the claimants on grounds that the particularization was done in the reliefs being sought from the court was done in the reliefs being sought. As in this case, the particularization which the claimant is asserting they have done was done in the paragraphs that claims the reliefs. That is paragraph 33 of the further amended statement of material facts, and it fell short of the requirement for special damages claim. See the case of Ocon Johnson and others versus Mobile Producing Nigeria Unlimited, reported in 2009 LPLR 8280 CA. This decision was affirmed by the Supreme Court in the case of Mobile Oil Producing Unlimited versus Ocon Johnson and others, reported in 2018 LPLR. In that case, the claimants also did claim for salaries and entitlement, and they also provided how much is their salary, but all these were stated in the reliefs and not in the pleading or in the affidavit evidence. From all I have been saying above, the claimants have not proved their claims for arrears of salaries due to lack of proof. They have also failed to establish deduction from salary for NHF scheme, tax, and pension. They would have done this by tendering the facelift, where the court will be able to see what was deducted from the claimant's salaries. And the claimants cannot also, from the claim put forward in paragraph 33 of the further amended statement of claim, it is clear that the claimants are claiming for the gross entitlement or for the gross salary, which is not allowed. They are only entitled to net salary, which is what they are entitled after deduction of statutory taxes and other statutory deductions, such as pension, tax, and the said NHF, which they are claiming refund for. For avoidance of doubt, the judgment of this court is as follows. The claimants in this suit have failed to prove their entitlement to the reliefs being sought from the court due to lack of proof of the special damages claim of salary, which is claim for salaries and emolument. Furthermore, by retracting their position in their final written address regarding the issue of when their termination took effect, the claimant have abandoned most of the claims they have before the court. Those claims are related to the issue of validity of the third defendant terminating their appointment and their claim or redundancy, They have all abandoned those claims in their final written addresses. The claim for arrears of salary emolument, report on NHM deduction of tax, all have failed due to lack of proof. It is also to be noted that some of the claims in the claims of the claimants were those that are not supposed to be paid directly to the claimant, but they are to be paid to the third parties. This include the pension deduction, the tax deduction, and the issue of national housing scheme. These are all claims that are to be paid to a third party by law. The claim on pension is struck out for non-fulfillment of the condition precedent to accessing the fund. The 28th, 29th, and 30th defendants are hereby non-suited due to their misjoinder because their claimants claim because the claimant was not in the same the claims against them their claim was not on the same or on the same transaction with that of the other claimants. Likewise, the first defendant is not a proper party in this case, and it is hereby struck out for from this suit. All in all, the claimant failed to prove their entitlement to the relief being sought. Judgment, I make no order as to cost. Parties are to bear their cost. Judgment entered accordingly.
As court pleases. We're very much obliged, my lord.
You're welcome.
We are most grateful for the erudite judgment and we thank my Lord for saying.
Yes, registrar, call the next case. Thank you,
my lord.
counsel.
Yes, my lord. NITN ABJ 03-2018 between Okoro Joseph and Leisure Investment Capital Limited. My lord, the parties are absent.
Any appearance? Any appearance? There appears no appearance.
Okay, my lord. 2019. In 2014 to 2021, how many years? From 2017 to 2020.
This is the third time this case is coming up for adoption of terms of settlement, but the parties are absent. In the circumstance, pursuant to Order 45 of the rules of this court, the terms of settlement are hereby deemed to have been argued. In the circumstances, consent judgment is as follows. The parties in this suit have, by the terms of settlement filed on 16th day of March 2021, settled their dispute and asked the court to enter the terms of settlement as consent judgment of the court. It is to be noted that trials has been concluded and parties have filed their final written addresses. It was while the case has been adjourned for adoption of final written addresses that the parties filed the terms of settlement filed their terms of settlement. In the circumstances, I hereby enter the terms of settlement by the parties in this suit filed on the 16th day of March 2021 as consent judgment of this court, binding on all the parties as final judgment of this court. The consent judgment is entered accordingly.
As the court pleases. As the court pleases.
What's the next case?
Yes, my lord. Suit number NICN ABJ 04-2018 between Monday Benedict and Leisure Investment Capital Limited. My lord, the party is absent.
Any appearance?
Yes, sir. Yes, sir. Welcome, sir. Yes, sir. But this is the last one. Yes, sir. Tomorrow night. Because he said he wants to.
Matter is for adoption of time of settlement. However, the parties and their counsels are not in court and have not written to the court as to why they are not in court. From this case came up on 7th day of July 2021 for adoption by the parties and council, and their parties and council were also not in court on that day. That's why this matter was adjourned today for adoption of the terms of settlement. In view of the foregoing and the terms of settlement filed before the court, the terms of settlement filed by the parties is hereby deemed to have been argued. In the circumstances, the court will proceed to enter the terms as consent judgment. The parties in this suit have, by the terms of settlement, settled their dispute out of court. This was after conclusion of trial. The terms of settlement filed by the parties are hereby adopted as consent judgment of this court as settlement of the issues in dispute between the parties. As judged between the parties, the consent judgment is binding on all the parties and can be enforced as judgment of this court. Consent judgment entered accordingly.
As the court pleases.
Any other matter?
No, my lord, that's all, my lord.
Okay, you should note these two cases with this consent judgment, so you will include them in the quarterly return. I hope you are here in the registrar. Registrar.
My lord, I've added it to our judgment for the quarter as consent judgment, my lord.
Okay, okay.
Yes, my lord.
You will indicate that trial has been concluded and witnesses are testified, because
Yes,
we
my
have
lord.
concluded trial in it.
Yes, my
And
lord.
witnesses have testified. Thank you
Okay.
very much.
Thank you, my lord.
Tomorrow,
My lord,
what is
please,
the time for tomorrow?
witness on each. Okay, my lord. My lord, please, on each, was it one witness or two?
One for each.
Okay, my lord.
One
Thank you,
for
my
the
lord.
claimant, one for the defendant.
That's true. Thank you, my lord.
What time is tomorrow's sitting?
My lord, 9 o'clock.
Are you sure?
My lord, that was what we agreed last week. You said 9, so that we'll finish by 12.
9, it's 9 now. Have you, has this man, what do you call him?
Mr. Fatai.
Fatai, has he scheduled the sitting for 9?
My lord, I told him that very day after you dropped your call. I told him that, my lord.
Okay.
I'll call him again now to remind him.
But if he has not, he can't do it today. If it is at 10 o'clock, he would, but confirm from him. If it is at 10 o'clock, then we have to leave it 10 o'clock, because you can't change it today and expect the parties to know.
Yes, my lord.
You can find out from him. If it is 9, okay, it's good. And
Yes,
if he has not changed it, then we have to do it by the 10 o'clock.
Yes, my lord.
Thank you very much. Have a
Thank
nice
you, my
day.
and
Okay,
thank you, my
bye.
lord. Yes, my lord. Bye.
Greet you.
Yes, my lord.
Administrator, you can end the sitting.